Right, good day everyone. Today we're going to talk about the most common criteria for EB-1 STEM cases. And for EB-1 STEM cases, we've outlined what's easy to do, what's more difficult criteria, and to kind of help you understand what it is that will help you get your case through if you want to go down that route. Now, this is the second week we're talking about EB-1, and the reason is we're getting a lot of questions. And in as much as we would like to answer all those questions one-on-one, we figured to do a session about the do's and don'ts, the hints about, under the hood, if you will, of the most common criteria for EB-1 STEM cases. And then we're going to be taking your questions and answering as many of them as we can. My name is Sam Shihab with the law firm of Shihab Burke, attorneys at law from Columbus, Ohio, and with me is my partner,
Brian Burke from that very same place, Shihab Burke. I'm going to be more specific. We're in Dublin, Ohio, which is just outside Columbus. Absolutely fantastic place to be. It is Monday, it is 6 o'clock, and that means we're here doing what we do every week.
Yes.
So
why EB-1 became a big deal as a year ago? And I may have said that last time, in the 28 years I've been practicing immigration law, we've gone through waves.
Sure.
Sometime EB-1 is not easy to get, and then other times were a lot easier, and then it back and forth. We are probably in an era where it is easier to get EB-1 than prior years. And why is that?
Well, we don't talk about politics, but politics, immigration is kind of inherently political in the United States anyway. And sometimes, let's say, immigration is something that's handled by the executive branch of the government, and there's an individual at the top who kind of sets policy on the way from the top to the bottom. And the people who they hire to be the top people in certain agencies, what they want to do with that filters downwards. You get sometimes where immigration is nice, sometimes where immigration is medium, sometimes immigration is hard. And right now, politically, we have an administration that they are broadcasting that they like employment-based immigration, and especially in the STEM occupations. As a lot of people know, H-1B, it's a very nice time for H-1B. The policy is wide open and they're approving a lot. But what people don't hear as much about is that they're sort of encouraging, STEM immigration in the broadest sense for folks in STEM fields. And what I suppose I will do is as long as everything worked right, I'm going to put up a little bit of a quote from a White House statement on STEM occupations, individuals in STEM fields that is probably relevant to this. Hey, there it is, it worked. So this is from a White House statement on sort of the value of bringing people in STEM fields to the United States, and even bigger. And here's what it says. In the fields of science, technology, engineering, and mathematics, STEM, fields that are critical to the prosperity, security, and health of our nation, our history is filled with examples of how America's ability to attract global talent has spurred path-breaking innovation. This innovation has led to the creation of new jobs, new industries, and new opportunities for Americans across the United States. Our commitment as a nation to welcoming new talent has long provided America with global competitive advantage, and we must continue to lead in this effort. Now, Sam, for me as an attorney, that's a sort of text that I'm going to go quoting in my legal cover letter for an EB-1A application, just because it's so good.
And this is the White House setting the tone for the agencies.
Yeah.
When the White House publishes something like this, it's telling all their agencies, this is, as a president, vice president, is important to me. Please do what you can, bend backward to carry out and effectuate my policy, which is to hand these smart people green cards.
Yeah.
And therefore, we are in a very positive environment for EB-1, A, B, or C approvals.
Yeah.
The second problem, Brian, that I see is the long backlog.
Yeah, that's what we kind of zeroed in for a little bit. We got a little bit into the data last week and perhaps didn't save time for this stuff. But yeah, It's even for India, EB-1 final action dates are now in 2017, which is kind of a bad prospect for somebody who is just getting to the United States hoping to immigrate. But there are people who are in the EB-2 or EB-3 backlog who might be eligible for EB-1A, and with a priority date of 2015, 2016, 2017. That suddenly becomes, quite an attractive option. You go overnight with an approval of an I-140 in the EB-1 category from waiting for an indefinite amount of time for a green card to being able to apply, and as long as the priority dates, stay where they are, being actually able to get a green card filed, and not just filed, approved.
Yeah. It's very difficult for people to understand the impact of immigrants on the day-to-day life of Americans. I had a consultation today, Brian, and I got on a Teams consultation, video conference. That's what they requested. And the spouse gets on the call, and I said, anybody else joining me in the call? And she said, yes, my husband, but he's in the other room on the phone. And I said, what does your husband do? She said, he's a heart surgeon, and he's in the cardiac unit, and he is on the phone saving people's life.
Gimme.
And
I want that case. I want his case too.
He came back, he got on the phone, and he said, 24/7 is my job, is to save life. That's what I do, I save life, he told me. And he means it. He's not bragging. He's a very humble person. I've talked to him. But that's the people, that is an EB-1.
Yes. No, I want to write that case. And that story is somewhere out there in the world. There's a top heart surgeon. And you know where he's not working? In the United States. Do you know where he could be working? In the United States.
And the examples is infinite in what we do. And if you're able to carry and translate the critical role you play to ink on paper, you get an approval.
Yeah.
And we're here to talk to you about the easy ones to get, the ones that are kind of like very easy, and in the medium, and then more difficult. Take it from here.
Yeah, so let's talk about that. So I'm just going to put it on the screen a brief minute and sort of an overview of, there it is, those EB-1A, well, the overview. Their sort of goal, their ideal is people who are at the very top of their field. You must be able to demonstrate extraordinary ability through sustained national or international acclaim, and you must seek to come to the United States to work in your area of extraordinary ability, and that's going to benefit the United States. So for me to sum it up, hey, Mr. or Mrs. So-and-so is out there doing awesome things that are absolutely amazing, and if you allow this person to immigrate to the United States, well, they're going to be doing those in the United States forever, indefinitely, sure. And that's the sort of people we want. That's the sort of case you write to the government. So just as a reminder, the challenge, one of the challenges in meeting the requirements for EB-1A is establishing that you are, one of those extraordinary people. And they give you 10 criteria you can meet to get there. And usually, Sam, when we're doing one of these presentations, we sort of, not go into too much detail, but today we're going to sort of delve into a couple of them.
Sure.
And particularly, the following ones. Membership in associations that require outstanding achievements, original artistic, athletic, or business-related contributions to your major or to your field of significance that are significant, and evidence that you command a high salary in relation to others in your field.
So to clarify to everybody, these 3 ones that we've highlighted in bold out of the 10 are the easiest to get. Now, you don't have to have them and you still can get approved, and we will discuss that, but we're starting with the ones that are, if you meet them, it's almost like money in the bank.
Yeah.
Right?
Yeah, and we're kind of STEM focused on this one, not for people who are out there in academia, because if you look at this list, a lot of these things are, putting out, academically reviewed papers and judging the work of others in your field. That's more of acclimatized towards academia.
Not to exclude people in the business that do that.
Yeah. There's people in business that do that, but there's people who are out there, working for good companies with a good job, and those people are. Just the point is, those people might be eligible for EB-1A as well.
Yes.
So the first, criteria I'm going to touch upon is commanding a high salary. So basically, if you command a high salary compared to others in your field, you might be eligible. That's one of the criteria you can meet for EB-1A. And for me, when I'm thinking about making an argument based upon that, Sam, I think about two things. Well, one, the easy part of it is, hey, what's your salary? You know, that's easy. Tax returns, W-2s, offer letters, employment contracts for your company that show what you get paid. Very easy to every person who is employed in the United States should be able to produce that kind of evidence. The part of it that can be challenging is really establishing whether your salary is high in comparison to others. And, you know, there's certain factors you have to consider. You know, location. $250,000 a year is going to be very high for somebody, you know, in the upper peninsula of Michigan, but it could be low for somebody who is, you know, in Southern California or New York City, or average at least. These are things you have to think about. You also have to think about, you know, who is really comparable to you. What people are out there, and are they? I guess it's really, what is your field, and who are the people in it, and how do you find those people, and how do you show that they are comparable? Because, you know, if you're sort of, you know, let's say your area of expertise is AI, and your field is this, and you're comparing yourself to run-of-the-mill, you know, day-to-day computer programmers, it might not be a good comparison. But fundamentally, there's ways you can do it. I mean, for me, a lot of people probably in our audience are on H-1B visas, right? And when I think of H-1B visas, I think of H-1B.
Or EADs.
This is true. Well, I'll stick with me because I'm going to stick to an important resource you might consider. For all those H-1B visas, there are, you know, wage data out there from the Department of Labor. The first step might be to look at where your salary is versus, you know, other people who are in your broad occupation in the place where you live. If, you know, the level 4 wage for a software engineer in Columbus, Ohio is what, $120,000 or so, and you're making double that in the area, I'd say, wow, you know, you might, you know, sounds like a good place to start. There's other resources you can use. You can use outside wage surveys, which, you know, a lawyer can help you sort of figure one of those out, and you can get actually opinions from like experts, like outside experts, like economists, who might be able to say where your wages are in the field.
I find it hard to believe for people to not know that they command higher salary in the field, because they know their field, and they're going to tell you, you know, I make a lot more than most people in this area.
Well, I mean, it's the field though. Doesn't everybody who works in this field, you know, make a lot of money? It's money because it's a fancy field.
But they will know. I mean, they'll say an average person makes 170. I make 300. I make 320. I mean, they know. They're going to give you the clue.
Yeah.
And the question is how to prove it. But proving it obviously is what we do.
Yeah.
I mean, a high number is clearly a high number, you know.
Well, yeah, I think there's certain numbers that are high everywhere, and you know,
if you make 80,000 and average people in your field is 35, that's not going to be impressive. I think the number has to be high of its own.
That's a great point. Yeah.
You know, it has to be high of its own, and then it has to be higher than comparable people.
Yeah, I guess the point is, you know, well, okay, you make $120,000. Well, every software guy all around the country, you know, makes that sort of wage. So that's not really going to impress us.
Yeah, and if you're making 120, everybody make 90. That's not good enough.
Yeah.
Good point, Brian.
Yeah. So the bottom line though is why does the commanding a high salary one come up first for me? Because there's a good bunch of people out there who already meet that requirement. It's already on paper. They already have the evidence in their hands, and for a good portion of those, I bet it's really a relatively easy task to prove it, essentially, because the wages are high enough such that, you know, you're going to be showing that to a government officer, and they're going to go, wow.
Numbers don't lie.
Numbers don't lie. Numbers, I love numbers.
Most of the time, right? Most of the time. Numbers don't lie most of the time. And it's a straightforward thing. You have it or you don't have it, and if you have it, we can show it. If you don't have it, it's not the end of the world. There's other criteria, but if you have it, boom, 1 out of 3.
Yeah. Well, for me, you know, it's a good important criteria for me because, you know, aside from, you know, academia, which has kind of a different universe, you know, people who are out there in the world working for companies, you know, if you're telling me you're important, and why aren't they paying you you like you're important, because part of the EB-1A case is sort of a totality of the circumstances analysis at the end. And you're telling me you're important, you made important contributions, but you can't, but they're not paying you accordingly, especially in the private sector. I mean, it's a criteria. I think it's a good, I don't know, a litmus test, a bellwether, a canary in the coal mine, to use a couple metaphors for where you might be in terms of an EB-1A case. So the next one I want to hit is original contributions to your field. So I'm going to put the list up again. That's the one right here in the middle. Original scholarly, artistic, or athletic, or business-related contributions of major significance to your field. So this is one where I think pure madness to send an EB-1A case out the door without making an argument on this issue. Why? Because when I talk about about the general sort of overview, the story of an EB-1A is so and so is doing awesome things in their field, and well, you're telling the government this person's going to do great things in the United States. For me, then, I think the greatest predictor of the future is what has happened in the past. So if you're saying I'm going to do great things in the United States when I'm allowed to immigrate, I think you darn well better should be able to tell the government I have done some awesome things in the past. And I think everybody has to make an argument on this criteria, but really the level of challenge and whether you can meet these things, I think everybody has to make an argument, but there's sort of in my mind, a certain strata of who has the best case and who has the more interesting case to make, but I think you have to make it for everybody. For me, I think that there are certain pieces of evidence out there that are just super good in terms of contributions to your field. Number one for me on the easy category is publish academic papers. If you have a couple published academic papers, for me that's kind of a good case. Why? Because academic papers are reviewed, are peer reviewed, they're published, they're put out there in journals where the whole point of those journals is to say, look at the cool things that are going on in their field, and it's been reviewed by peers. Even better if those papers have been cited by others. That says to me, not only was this published by people who were experts in the field, who thought this work was worthwhile sharing with others in their publication, other people have built upon this work by citing to it. Great. Academic papers, great. Now, problem with those is they aren't really as common in the business field, and people often come along with their company, their publications that come through their company, and they say, well, Brian, can I make an argument for that? My answer is maybe. Depends upon who the company is. If your company is sort of eminent in your field, and they are the name in this, and they're saying if they're the name in this, you're an expert in this, and they trust you to speak on behalf of the company in the subject on the area of this, I might try to make an argument based upon that as well.
So the recent USCIS policy has encouraged comparables.
Yes, comparable evidence.
Yeah.
So that's an excellent example.
And so now
of that.
USCIS is saying, bring the comparables. Don't be restricted by this list. If you have something similar to what we have listed, but not exactly,
they're really encouraging.
Yeah, come and show it to us. We may buy it. Yeah. So that's one thing. And two comments on that, Brian, from my standpoint. On the published material. The citation, all these things, extremely important. What you just mentioned really is the essence of winning a published material criteria.
Sure.
But two things, in my mind, I'd like to add to. The first is the nature of the material. That's on the not very academic side of the analysis. If the reviewer can read it and relate to it, you are a lot more likely to win on that one. If you say solving a problem with a traffic light accidents, for example, with some kind of circuitry or design of a traffic light, I'm just thinking saving 1 out of 8 accidents, and then translate to life saving, a calculation, you've saved 600 lives a month in the USA, they can relate. They can relate to that. But if you do abstract mathematics that and we came out with an equation that nobody was able to solve before.
Yeah. Why is it important? Why is it important? Is an immediate question.
Yeah.
If I'm talking to somebody about an EB-1A case, I'm saying, well, why should anybody care about that? Why is it important? And that's that's kind of on the more challenging side of.
Yes.
I have to translate
The
that
story.
into plain English so that somebody who's never heard of you who's reviewing a case and trying to get it done in an hour,
The story is critical.
Yeah. Yeah.
And then also the other point is longevity. So if your discovery happened a long time ago, they're less likely to be excited about it. So the timing of your application, so if you've done something similar that was great 10 years ago, you really have to prove that as of today, it remains to be the most important thing.
Yeah.
But if there has been a series of discoveries that kind of put yours in the in the background, they may say, well, it's not as important now, and therefore.
I would want to look at the citations on those papers outlining the other discoveries.
But do you see what I mean?
Yeah, no,
yeah. It's similar to the athlete who won the gold medal 15 years ago. Now they're not competing, and they're coaches, and they're saying, well, he's a coach, but I cannot. Do I look at his or her achievements as an athlete to evaluate them as a coach? Do I look at their achievement as a coach? That kind of a thing. Yeah. So the time between your work and the application is relevant. That's all what we want to say.
So other one on the easy list I want to say is patents. You know, if you have a patent, I want to talk to you about an EB-1A case, because patents are, government filings where a government officer somewhere has said, this is new, this is novel, this is distinct from everything else, everything that's patented out there, and it's probably got the backing of a company. That's sort
fantastic.
of, yeah.
That's fantastic stuff.
Things get a little bit more complicated when it comes to things that are, not published or patented or things like that. But imagine this scenario, Sam. Imagine you're an engineer in autonomous vehicles for a major automotive manufacturer. That's somebody where I think you can, as long as you're making important contributions to that, that's somewhere where I think you have sort of a not a terrible time making your argument for contributions to your field. Because think of it. Autonomous vehicles, you've probably seen a couple of those around, you've probably read news articles. That's me. That's what I do for a living. And something that's very easy we were talking earlier, something that's easy to understand
and relate to.
Yeah. And the only challenge there is then really kind of documenting your role, and you're going to be able to do that with your work. And like you said, where things get absolutely difficult is your theoretical math and that sort of thing. You have to sort of really kind of break it down as to why it's important, why you should care.
And that comes the letters. The letters that we ask people sometimes to produce, professor to explain that this equation now has infinite, infinite applications.
Outside experts can really
infinite
help.
application. And we don't want to digress because there's a lot of examples. The Nobel Prize winner that won for the COVID vaccine at the University of Pennsylvania, I believe. Correct me if I'm wrong. I apologize if I made.
It's the person who allowed us to get to RNA vaccines.
Originally, her incredible work was dismissed by the school. As a matter of fact, she was demoted because they found out they assumed that she's wasting their time, and now she's been recognized, and all the institutions are asking for an apology. But why? Because she could not relate her work to a real life. She could not connect her incredible discovery to a real life, and therefore this would have been a difficult EB-1 case. After COVID, it's a Nobel Prize. Are you kidding? No, it is a Nobel Prize. She won the Nobel Prize this year.
Well, that's a very easy easy EB-1A case.
And that's a slam dunk EB-1. Of course, she's a U.S. citizen. She doesn't need it.
That's you photocopy the Nobel Prize and you call it a day. But choosing the last criteria was a little bit difficult for me, Sam, the top one, because there's a lot of them out there, performing a leading critical role at other organizations was sort of my next one I was sort of fighting with, but I chose to go with membership in associations that require outstanding achievements as the last criteria. Now, I'm not a member of any associations now, Brian, so why are you putting this one on the list? For me, it is one that is achievable. It is something that, is within your grasp. It is something where you can put in work and actively sort of campaign for yourself to get there, which is why I put it here. So on the good side of that, you can campaign and get yourself, but get a membership in an association. Well, it's membership in an association, Sam, that requires outstanding achievement, right? So for somebody who's in a STEM field, I would say, type your field of expertise into Google and add, professional association or association and see what's out there. The problem is, the challenge with this criteria, it's not just associations that you can join by paying a fee. It has to be ones that require outstanding achievement.
And some kind of a committee on the association side that reviews every application for achievements and decide to allow people or not to allow people. That's one of the things they look for.
Yeah.
And for any of you guys, sorry Brian to kind of jump in on you.
No, please.
But for any of you guys who want to explore that, USCIS policy manual, and you can probably look that up, it's outside the scope of this presentation, mentioned few of them.
Yeah.
That they recognize.
Oh, yeah.
So you don't have to reinvent the wheel, just start with them, and then once you learn about these mentioned by USCIS, you can go and see what comparables out there similar to this out there that's closer to my field that I could become a member of, that can help me meet the criteria, and just pursue it.
Yeah. I mean, I would note in terms of comparable evidence too, I mean, there's probably all sorts of, if ever you're asked to, because of where you are in your field, to be involved in something, it's the sort of thing where I'd say, that might be the sort of thing that is comparable to membership in a field, membership in one of these associations, because, I always think of these associations and groups a bit more academic leaning, but if you've been invited by a college or university to be a part of a board for business relations in your field or that sort of thing, is the sort of thing that I might think is good comparable evidence as well.
Yeah.
So we wanted to hit 3, Sam. We've hit 3.
Yes, and we can talk about this for the next 3 hours if you guys have the patience to listen to 2 lawyers talking about it, because we enjoy.
We get excited about these things. Yeah.
We enjoy these cases, but we have better and more important things to do, which is to answer your questions, and we're going to jump in and answer them as they come, and we're going to do the best we can to move and get as many of them as possible. Before we jump into them, just to remind you that there's no attorney-client relationship established because we're answering these questions. Do not make a life-changing decision based on what you hear from us today. Always consult with a qualified attorney of your choice to decide whether something you've heard from us is relevant and applicable to your case after they look at the full details of your case. Without further delay, Brian, let's take it from Ram KC. He got a question for us.
Sure.
If you can make that bigger, that'd be wonderful.
Because there we are. Okay.
All right.
So, hello, Sam and Brian. Do we also need to carry expired passport along with new passport while on green card? Thank you. So, generally speaking, you shouldn't, but I can imagine scenarios. One that we stumbled across quite recently, where I think it might be relevant. Perhaps if your name has been changed in your country of, or the ordering of your names has been changed in your country of origin, and you have a different passport, you might want to have a copy of that old passport that shows, this green card matches with my name, for example.
Okay. So that's probably
pretty much the only one scenario I can think of.
Yeah, because my answer would have been no, heck no, you don't need it if you're a permanent resident. But Brian very smartly came up with the scenario.
No, and Brian did not come up with that scenario. A client came up with that scenario, and they said, "I just got my green card, and then my name has been changed."
Even then, I think matching the pictures.
Yeah, that's true. Yeah.
But I think you'll make your life easier by showing the old.
Yeah,
passport.
I would. Anytime I have some sort of potential for an immigration dispute, I'm going to try to send somebody in, fully armored and with a copy of the old passport might be useful.
Now, just before we leave Ram, KC's question, if you are in the U.S. and not traveling across border, there is no need to carry any passport whatsoever. This is if you're traveling into the U.S. So if you're traveling from Kentucky to California by plane, you do not need a passport. If you're going to Hawaii, you do not need a passport.
Yeah.
Hopefully that clarifies it. All right. So let's take the next one, Brian.
Yeah, so let's see what we got. let me see what this person says. Explorer Dreamer. Looks 5-year EAD and AP is going to be a combo card for all GC EAD applicants. Did you guys understand this in any USCIS statement release? So
I haven't seen it.
yeah, well, we saw in the release. There's nothing about APs, and I can't help but think that they would be reluctant to give a 5-year AP because I guess what the things they're evaluating is whether you can say.
I haven't seen anybody getting a 5-year EAD AP. If anybody of you guys have received one, drop us a note, right now or after. If you watch this video after hours, just drop us a note and share it with everybody. I would love to see the 5-year advanced parole, but I haven't read anything official.
Yeah.
And I haven't seen anybody that told me that they got one.
It wouldn't surprise me if we suddenly started seeing it, though, because sometimes USCIS doesn't announce things. Sometimes overnight
Honestly,
they just start doing something different. Yeah.
If they want to dig themselves out of the big hole that they're in, they must do something extreme like this.
Yeah.
I mean, they are in a hole so deep in terms of processing. Unless they do something extreme like this, this is going to be a perpetual nightmare for everybody involved. Yeah. So yeah, I am all for it. How chewy? I believe.
So I will give it a read here. After green card, can I work for my employer/sponsor part-time for the next 12 months and take on another full-time job or start my own business? Will this cause concerns with N400 5 years later? So I'm going to start with maybe a high-level explanation. Your employment-based green card is sort of an agreement between you and your employer. It is the employer saying, yes, we're offering you full-time permanent employment in the United States, and you saying, yes, I'm intending to take that. That's my path to a green card. Handshake. Everybody agrees. Mm-hmm. And not only that, you're signing a bunch of government forms, swearing that that's what you're intending to do. Mm-hmm. So I think that anybody going into getting a green card should be planning to stay with their green card sponsor, whoever it is, the original I-140 petitioner or whoever's supporting them with a supplement J, indefinitely in getting that green card. Mm-hmm. Once a green card is in your hand, there is more flexibility. I would say that if I wanted to evaluate whether or not somebody is, fulfilling the full-time permanent employment, part-time with your sponsor is not that. That's not what you said you were going to do. However, circumstances can change, and there are any number of circumstances where you might end up, taking another job or opening a business as well.
Excellent review. I will add.
Please, because there's a lot of nuance here.
A little bit of salt and pepper to it.
Yeah.
Okay. It depends on the facts.
Yes.
So this is very fact-driven. So I'm going to give you a fact-driven scenario that's not good. I'll give you another fact-driven scenario that's good under the same question. So here's a fact scenario that's not good. Hey, we're not doing so well. I'll keep the green card going because you've been such a good employee. But the moment we get that green card, you go part-time. That is not good. Why? Because now the employer has no intention of employing you full-time. Or you go to the employer and say, you're applying for a green card from me. I'm going to continue full-time until I get that green card. I'm going to drop to part-time because you're not paying me enough. I can make a heck of a lot more money outside. That's not a good scenario. A good scenario. Now, example. Green card approved. 2 days later, employer comes to you and say, we just lost a big contract. I didn't want to tell you, but we lost it. We really wanted you full-time. We just cannot keep you. We can keep you part-time. All that happened after the green card is approved. Oh, okay, I'm sorry. You offer me part-time now. I'll take it, and I'll look for a job somewhere else. That's okay. All right? I'll go back and give you one more scenario that I thought of that's okay so people understand. 8 months after full-time of employment, after the green card is issued, you change your mind and you want to move on. You can tell the employer, hey, I don't want to work for you full-time, I want to work for you part-time, or vice versa. That's okay. Yeah. So all depends on the facts.
Yeah, I guess I would emphasize that full-time permanent employment does not really mean permanent forever employment. Permanent means indefinite. It means,
reasonable period of time.
Long-term, reasonable period of time. You're not obliged to stay with that employer forever. Can this cause concerns at the N400 stage 5 years later, Sam?
In general, I don't see that a problem.
Yeah,
I do not. I have never seen. But you know, weird things. We say it today, and then tomorrow it becomes an issue.
Yeah.
I don't see, have not seen, do not know what will happen in the future. This issue before, but if you're based on what I've told you that you're covered, I think you're in good shape.
Yeah, I think I would get. I haven't seen it, and I would be surprised if the folks at the local USCIS field offices processing citizenship applications have these sort of thought processes related to your path to permanent residence 5 years ago to really kind of analyze whether that was, you know, in good faith in the eyes of the government.
Yeah.
It seems pretty unlikely. Yeah.
I've attended a countless number of naturalization interviews throughout the years.
It's really come up how you got your green card.
Never
Yeah.
a question
Yeah.
that comes up.
Yeah.
It's focused on your residency in the U.S. Do you have any criminal record? Usually a naturalization application is a happy application.
Yeah.
You know, you prepare for the test. They ask you 5 questions or 3 questions.
Yeah.
You answer
It
them.
takes your permanent residence as a given, generally speaking, yeah. Unless you have weird travel and you haven't been outside the United States for a long swaths of time, that sort of thing.
All right, next
Yeah.
one. Harry Guru, question number 1 of 2. Hi, Sam and Brian. Thank you for these informative sessions. Wife and kids adjustment status is pending. Priority date is August 2013. India EB-3. For medical reasons, they plan to relocate to India and stay for an extensive period. Let's go in for the next part from Harry Guru.
Here we go, 2 of 2.
So I am the primary and plan to continue in the U.S., guide U.S. What happened to their pending adjustment status if they stay outside the United States for a long time till medical RFE or some other RFE or priority date becomes current? Okay, so first of all,
Good question.
sorry about the medical situation the family is facing.
Yeah.
It's always a challenge. But the medical situation has no impact. This is just the personal information that you've shared, and we thank you for sharing. Will not change the case because obviously we're in a country that offers the most advanced medical coverage. There's never an acceptable excuse to leave the country, but it's not really impactful anyways.
Yeah.
So if they have a valid advanced parole and they're outside the U.S., they can definitely continue the adjustment status application. If they're able to come in and renew that advanced parole and leave, for as long as you can do that, you're fine. But obviously, prior date, you could be here for years, and that's a long time.
Yeah.
Especially that maybe not for medical reason, maybe for personal reason, you want your children to be raised back home. You want them to go and engrossed in the Eastern culture that makes the foundation of who you are as a person from India, and you want your children to experience that. A lot of people do that. That's wonderful to do that. Now, if you're not able to do that, and just say that because of school or personal reason, you are unable to continue the adjustment status, and it's abandoned. So the children and the wife abandoned, and obviously their ability to come to the United States is going to be restricted. You have to be aware of that. Your ability to go and visit is not a problem.
Yeah.
There's something called following to join.
Brian, that's where my
Brian is
brain
dying
was
for
going.
me to get to there. So I'm going to give it to Brian to explain what following to join
So
is.
yeah, you were talking about the details, and I was kind of sitting up here at the high level on a cloud, going, doesn't matter. You could wipe out. This person has said, I'm the primary person. I'm going to be here in the United States the entire time. I'm immigrating, right? No doubt about that. Bottom line, the U.S. immigration process allows your pre-existing, children, spouses to immigrate to the United States with you regardless, so long as they meet, the general eligibility criteria. So if he's immigrating, so will the rest of his family. So even if the adjustment of status cases were wiped out, and Hari Guru gets his green card, his family members would be able to apply for green cards through the consulate. Aside from the fact, Child Status Protection Act, all these other criteria still being out there, of course.
Well, the Child Status Protection Act, which protect your child adjustment, can be impacted in light of this new criteria that
They'll go by dates for
filing. So it could be impacted.
Yeah.
So if it is an aging out situation, there could be an impact. That is going to be definitely one of the things you want an attorney to look at the full details for you. So that's kind of a side note for you to understand. Following to join, other than that child status protection, of course, it's the elephant. It's the elephant in the room.
I could not bring it up. Yeah.
Yeah, but beside that, if you take that aside and move it, believe it or not, following to join is indefinite.
Yeah.
Long time ago, many years ago, following to join was 1 year. And they took that law, I mean, obviously, I've been doing it for a few decades, so they took that off. Now it's indefinite, you know. You can do following to join as long as there's a viable, valid marriage and the children are under the age of 21. At the time you act on the case, following to join is valid, and you can do a counsel processing through that for the children. Excellent question from Harry. Not a typical one that we receive.
Yeah, good one.
So we appreciate bringing unique questions because it gives everybody a perspective. Brian, if you can find the next one for us.
It's always hard to. So there's Hari Guru part 1, and there's Hari. I saw Hari Guru, but there's another one in the middle here from How, who was sort of maybe follow up.
Yeah, and then we'll just go back to Harry if he has another question. So go ahead, Brian.
From How again. I-140 and I-45 concurrently gone through interview and provided bona fide job offer from my employer, the sponsor. RFE on Supplement J missing. How do I respond? If Supplement J provided, when should I expect approval? So Supplement J missing does not surprise me. I would have no doubt that you handed one in and. Well, go ahead.
Yeah, no, go ahead. No.
Well,
I'm listening. I'm just flabbergasted that they've lost it.
Well, so here's my take on Supplement J.
It's just for me, I can't believe this.
If you were, so I-40 and I-45 filed concurrently. If you read the forms, a Supplement J is not required in that scenario. But I have learned you do not rely upon that policy because when you get to an interview, the officer is going to expect a Supplement J. You can quote, well, actually, the forms don't require one in my scenario. They don't care. They want a Supplement J to make them feel warm and good, to make sure that your job offer from that original I-140 sponsor is still there. My general advice for going for an interview with this, sorry, Sam, is bring a Supplement J.
Yeah, we always request Supplement J, and then the immediate question, is it required? And we say no. And then I get this look from the client. Why are you asking me to prepare something that's not required? Well, I'm gonna bring this story to let them know why we do that. We do that is because we understand that it would have been fantastic if How went into the interview with this extra Supplement J, and they go, we don't have it. And he goes, here's the one. Approve my green card now.
Yeah.
Because now he has to go through red tape one more time.
Yeah, for those who don't know, at an interview, if you've never been to an immigration interview, it sometimes comes up in the conversation, I don't think I have X, Y, or Z, and sometimes it's okay, well, we're happy to give that to you on an RFE, but it's a great winner to be able to hand that in. Some officers do know that they don't need a Supplement J or don't want one, or are able to find one when it's previously submitted if it was a transfer on an underlying basis, but I've been in that scenario for sure.
And this is not an adjustment of status presentation, because obviously priority date is not moving and the adjustment of status are not common. But one of the key things that we advise people is this: all the evidence that's required, bring it with you, and bring an extra copy of that. Document, a birth certificate, bring a copy of that birth certificate. A marriage certificate, bring a copy, because they're going to say, well, it's missing a marriage certificate here. You may have supplied it. Well, here's the original, officer, and here's a copy for you, so you don't have to get out of your desk.
I love
Right?
I love that one.
Yes.
One. If somebody says, "Do you mind if I go make a copy of this?" No,
Yeah.
I have one for you. Great.
Yes.
I do mind because I have one for right here. It would be rude of you to leave the office.
Yes. All right, let's take the next one.
Here we are from PS.
If H-1B visa stamping is active throughout the duration of a visit to home country, and if there is a recent change in the employer, since last visa stamping, does one need to go for a new visa stamping, Brian?
No.
Yes,
Yeah.
correct. The consulate does not want to see you if you've changed employers and you have a valid visa stamping, even though
On the bottom of the visa it says, company A.
And then now you're working for company B. And even if you cross the border and you show them an I-797 with company B, but the stamping says company A, does the officer at the border care? Does he care that they are not matching, Brian?
He shouldn't. I have never heard.
He does not care. He does not care. He will not care. I've never seen anybody.
Our job as attorneys is to hear people's issues, and that's not an issue.
Never been a problem.
Yeah.
Never been a problem. So you don't have to worry about it.
Yeah.
All right. Sounds good. All right. Go ahead, Brian.
From Sachan, E26 GCEA green card received August 2022. Getting laid off have any impacts? Probably will getting laid off have any impacts on naturalization application for citizenship? Layoffs will happen this month. No. Well, okay. Never.
August 22. You're in October 2023, my friend.
Yeah. I mean.
Well, yeah. You got.
As soon as I say no as an attorney, I imagine some sort of fantastical fact pattern which we could somehow impact, but I can't fathom.
Well,
it.
not knowing more, the answer is no.
Yeah. Yeah. This is.
There's no impact. I mean, yeah. I mean, there is. I mean, if this is like the first two lines of a 150-page question with more, there could be scenarios.
You described this exact scenario earlier in your good scenario, but bad scenario. It's day after you get a green card, they say we just lost a major contract, and that's kind of sounds something like that.
Well, August 2022.
Oh yeah, this is a year after getting a green card. High five, no worries. Yeah.
As a matter of fact, you get unemployment benefits too.
Yeah.
And no impact.
Yeah.
Whatsoever.
No, you're still tolling up your time to apply for U.S. citizenship. So
you're fine.
Desire, I wouldn't worry about it. Yeah.
100%.
Yeah.
All right.
Okay.
I know there's some chatter going on, but we will go into the questions.
Yeah.
Right.
Let me see here. Here's a question here. I don't want to skip any over him. So from Sagar Kulkarni.
How lenient is USCIS in terms of I-485 job portability? Would quality assurance analyst healthcare be considered similar to management analyst healthcare position? Thank you. Well, I'll answer the first part. You're laughing. I'll answer the first
I'm always
part.
kind of laughing.
Yeah. In my opinion, USCIS is lenient. Okay. In my opinion, USCIS is lenient. Number two, on the second part of the question, the analysis is quite, I don't want to say scientific, but close to scientific. There is a memorandum by USCIS that outlined exactly the steps that you have to go through to evaluate one position to the other. And thirdly, which is I think maybe the most important thing to share, and I'm sure Brian has more to weigh in on this, the title is not the most important element of the evaluation, although it's relevant. It's what you are doing, okay? If you are doing as a quality assurance analyst a job that's very similar to management analyst, then it may not be that big of a deal. But if the difference is significantly different, then we'll have to go through a little bit more analysis.
When I think about this, I'm thinking, I see quality assurance analysts, I see management analysts, I start thinking of SOC job codes from the Department of Labor.
Yes.
And so I would encourage you, Sagar, if you do a Google search for USCIS same or similar occupation, you will find the USCIS policy handbook, which has a pretty darn good explanation of how they view this. Very readable, very, very nice. But, I think about management analysts, basically in that policy they say, generally if you're in the same big number, the first two numbers, as I read the policy handbook, don't take my quote for it, but they say if you're still in the 15s, which is where the IT occupations are, it's a really positive factor. I'm not sure management analyst is considered one of those 15 occupations.
I can't comment until I look at the occupation code.
Yeah.
But here's the thing that you have to understand. The requirement is not same job classification. Yeah. It is same
or
similar. Okay, and what is similar is outlined, is explained. Okay, so it needs to be looked at by somebody with experience and to help you out with that answer. But I can't tell without going through your job description, reading it carefully, make sure that it matches, and then go into the SOC code and pick up the codes and make sure that I compare them, and then we can answer the question.
Yeah.
All right.
Gonna keep it on going here.
Yes. So Brian, go ahead and pick
Emily,
Emily Marshall, who's being a regular now.
Yeah. It's nice to have regulars.
Yeah.
I like to think when we lose a regular, and I know it's because it's probably because they got a green card and they're
Yes.
done. Some people sometimes they come back and say hello every now and again.
Sure.
What do you guys think about the proposal of asking USCIS to not approve Indian national I-140 until close to current on the visa bulletin for CSPA on their kids? Delay approval similar to I-526 or F4 I-130. Interesting. So. Keep that I-140 pending for years and years and years in theory. Let's give a little bit of context. CSPA, your kids get the benefit of your I-140 pending for a long time. So somewhere out there, Sam is a miserable person who's, perm got audited, and then they got denied, and then they filed an appeal on the perm, and it's taken years. And then their I-140 got denied, and they have the long pending appeal on that, and it took forever. But they get a benefit because they get a bunch of time under the child status. Actually, they only get the benefit of the I-140 processing. Excuse me. They had a denial and appeal on their I-140, and had a long I-140 processing time accordingly. And they get the benefit of a long processing time on their I-140, a bunch of time under the CSPA. And Emily Marshall here is putting out the idea of, what if you just ask the government to just let your I-140 just slow cook on the spit for a long time to build in lots of CSPA time for your children, to use a metaphor.
Well,
how
Brian,
do you tolerate me, Sam?
Brian, you just asked the question in a different way. You didn't answer it, but you like it. You like what Emily's doing.
I think it's an intrigue.
It's not intriguing. It shouldn't be done that way because it circumvents the intent of the law.
Yeah.
The law is designed to protect people from government delays.
Yeah.
Now, when the government intentionally delay, it's absurd, right? We get into a situation that's absurd a little bit, Government, one side of the government say, you're not moving fast enough. On the other side, we're telling the government, please slow down. The government needs to do what the government needs to do based on policy in conducting their business. It should not be to force an outcome.
Yeah.
Okay? So as a policy, I'm not in favor of it. As an outcome, I like it.
Okay, so
because
you've dragged me into the conversation. I think, if USCIS, if the executive branch somewhere put out a policy that said, we're going to hold these for a long time, I imagine immediately an army of lawsuits against this, against the government for not doing their job.
Check a box if you want to approve right away. Check a box if you want to delay it to take advantage of the Child Status Protection Act. That would be nuts.
Yeah.
Right? That would be nuts.
For sure.
But I like Emily is creative. I like Emily. Emily smart. Maybe other people are talking about that.
Well,
but that's not the intent.
I mean, she mentioned. So Emily, I think we're gonna have to admit.
Similar to I-526 or I-140, I-130 approval because they're not approving those.
Yeah.
Forever.
Yeah.
Okay. But they're not approving them forever because they know that they will never be relevant. Most of them.
Yeah.
When the backlog is multi-decade.
Yeah.
Okay. They know that these cases are just basically filling space in a show. They'll never approve them. They will never look at them because these will be irrelevant. Because 20 years from now, they'll pick them and send an RFE, and then 2 weeks later deny the case. Why? Because nobody's going to respond. People have moved on. People have gotten old, too old to even remember.
Yeah.
Addresses have changed. People don't update their address. It's a crisis.
I think of another challenge related to this. I mean, what about the fact that people generally, if they're going to be Indian nationals, need an approved I-140 to extend their H-1B beyond 6 years to obtain other benefits, and not having that I-140 approved is,
But good idea. I like it.
Yeah.
I like the idea. I like creative. But at the same time, I wouldn't be surprised when USCIS comes with crazy policy like this every now and then. It's illogical, but it's problematic.
Yeah.
All right, let's take the next one, Brian. All right, take it.
So can EB, I'm going to assume that's 1A, be filed by employer, or does it have to be self-petitioned? If both, which one is better?
You can do an employer petition for EB-1A.
Yeah. Yeah, I mean,
I wouldn't do it.
yeah, I mean, I would prefer to say, you know, do an EB-1A if you have an employer that's got your back and is willing to give you, you know, good evidence. You know, if you have, you know, contributions to your field that are private and proprietary to your employer, and they're willing to, you know, share, willing to give a little bit of information that might, you know, back you up, for sure.
An employer filed EB-1A makes it stronger, in my opinion. Not on the law. It doesn't change it on the law. It changed it on the context, in my opinion. It makes a feel-good application for the reviewer.
I wouldn't have the employer, you know, sign off on the forms, but I would just basically, you know, you know, if the CEO of the company is saying, heck yeah, give Bill a green card, you know, definitely.
They can sign it. They can sign the I-140 petition. They can sign it and say, we're petitioning him because we love him, he's amazing, he has done all this work, and we have a job for him. And that's fine. It depends on your relationship with your employer. So yeah, it can be done. And which is better is depending on your fact scenario. You got a flip-floppy kind of a boss, I wouldn't let him touch the application.
See, that's what's crossing my mind. Well, they've signed it, now they're in control of it. You know?
Yeah, but you have a solid boss, you have a long-term relationship, and the work that you've done, a lot of it relates to the company. Heck yeah, get them to sign it.
Yeah, I would love.
And the company is a big company.
I would love to have the support of the employer. Yeah. I mean, if the narrative of the I-140 EB-1A is, you know, I'm going to do great things in the United States, it's, well, where are you going to do it? With these guys here, with this great company, which you guys already know because they're so important in the industry. That's where I'm going to do it. You know?
Boom. Yeah. Absolutely.
Yeah, and this is sort of a follow-up from Emily Marshall there on that question. Yeah, that is to have two I-140 delay approving the second while using the first to extend H-1B and spouse EAD. Well, that takes care of
Emily, you're so creative.
Yeah, that takes care of the issue.
I'm so impressed with Emily.
Yeah.
Just give her a shout.
I don't think we have a shout button, but I think we have birds. I'll give some birds. This is what this button says. We haven't tried these things for a while. Every now and again, we sit down and try to remember what those buttons do.
Yeah. All right. So Emily, but you have to remember that the I-140 that you have to use for the green card is the one that's delayed if it makes a difference. If the other one, if you use the other I-140, it may not be.
Yeah.
Can you file two I-140s in EB-2, both? In EB-2, one delayed, one not delayed.
I think.
Can you purposely file an I-140 incomplete?
You definitely can.
To take advantage of the Child Status Protection Act.
You definitely. Does that make your application in bad faith? Not really. No, I don't think it rises to the level of bad faith, in my opinion. Yeah. Now, some other people may disagree. Yeah. Because just because of the delay is so hard, such a big hardship. Yeah. Yeah, I would say incomplete application, clearly missing stuff can help. Yeah. Yeah, it's an interesting thought, and that one has definitely crossed my mind before. But generally speaking, we're not usually dealing with I-140s where we have an immediate CSPA issue. Those are really. We will be having more of that. This is true. Yeah. We will be having more of that. Yeah. The green card population is aging. Yeah, this is true. Pending green card, waiting for a green card population. To be clear. Emily Marshall, do we think the filing date will be allowed to be used until March, similar to last year? We have a good forgiving USCIS, and these priority dates are so miserable to begin with, so why not? Honestly, I don't see the downside of it, but nobody has a crystal ball. Yeah, there's a trend where, okay, so generally speaking, anymore, we expect the first visa bulletin of the year for USCIS to accept the filing dates. I don't count on that until I see it, and I don't really count on much beyond that, frankly, because if they feel they have too many cases, or they can and do roll the dates back. That's what we saw at the end of the last fiscal year. Yep. Yeah. From Vishal. All right, so how long after medical RFE do I get the decision? If the priority date is current for adjustment status, case I-45, it should be within 30 days, 45 days. Yeah. Max, you should get a decision. Yeah, sometimes, I would agree with those maximums. Sometimes they come Very
immediately.
quick. Yeah. If they're just waiting for one thing to a box to check to get the case approved, for sure.
Brian, it's 7 o'clock.
So does that mean we take one last question?
Absolutely.
Okay. Bing. So, does period of unemployment have any issues with naturalization or naturalization of citizenship applications? So, no.
No, does unemployment compensation, asking for unemployment compensation has anything to do with that?
No.
No.
Yeah.
Nope.
No. No.
You can be playing video games all day and not working as long as
I would advocate
you're
for
meeting your obligations.
Yeah.
That's right. You're meeting your obligations towards your everybody around you, and you're a good, good family member, good neighbor, good, you have a good moral character. What's a good moral character?
I'm gonna advocate for reading about it in the USCIS policy handbook. They have a not as readable as the same or similar occupation section, but they have a pretty readable section about good moral character, because good moral character is ill-defined.
It's really it's the character of a person, of an average person in the community. This is not a character of the most
the best.
Best. No, it is just an average. You have to just have, no government. You're not taking money from the government, not paying it back. You are a good father. You're paying your child support. No criminal background. No excessive.
I guess really what they're really looking for is evidence of bad moral character, and that's when things get
habitual drunkenness is a problem. Drinking and the problem. But if you don't have any of those issues, you don't have to work. To be a citizen.
Yeah.
Absolutely. All right. With that, we conclude today's presentation. Thank you for listening to us. We will be back next Monday, 6 o'clock Eastern Time. And any topic you guys want us to talk about, just drop it in the notes, and we will make note of it, and we'll bring it and break it up. Until next week, you guys have a wonderful